All right, thank you, everybody. I'm sorry that we're delayed. We just had a conversation between Assembly Council and the Municipal Attorney's Office. So as soon as they step in. So I now call this special meeting of the Anchorage Assembly to order. It is June 5th, 2023. It is 12:38 p.m. Mr. Clerk, would you please take the roll?
Yes, Mr. Chair. Mr. Myers? Here. Mr. Martinez?
Present.
Mr. Rivera? Present. Ms. Bronga?
Present.
Mr. Johnson?
Here.
Mr. Constant?
Here.
Mr. Cross?
Here.
Mr. Volan?
Here.
Ms. Brawley?
Sorry, here. And I
Mr.
need a different microphone.
Mr. Solt? And Mr. Perez-Verdia.
So Mr. Presverdy and Mr. Salt, as well as Ms. Zalatel are all excused.
Thank you. Mr. Chair, you have a quorum.
Thank you. Next on the agenda, we will have the Pledge of Allegiance. Mr. Myers?
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Mr. Martinez, would you please lead us in a land acknowledgement?
A land acknowledgement is a formal statement recognizing the indigenous people of a place. It is a public gesture of appreciation for the past and present indigenous stewardship of the lands we now occupy. It is an actionable statement that marks our collective movement towards decolonization and equity. The Anchorage Assembly would like to acknowledge that we gather today on the traditional land of the Dena'ina Athabascans. For thousands of years, the Dena'ina have been and continue to be the stewards of this land. It is with gratefulness and with respect that we recognize the contributions, innovations, and contemporary perspectives of the Upper Cook Inlet Dena'ina. Thank you.
All right. On this agenda, we have one item and possibly two, but unlikely the second. So you'll note on the item, I'm going to read it in the record in just a minute. It is listed for public hearing date of 6/20/23, but I'm going to ask when we get to the time for motion and a second and a third that the public hearing actually be set for Friday, the 16th, I believe it is. I'll just verify. Yeah, Friday the 16th as opposed to Tuesday the 20th. So 6/16. So before us, we have item 4A, Resolution AR 2023-196, a resolution of the municipality of Anchorage reappropriating $2,455,351.93, all within the area-wide general capital improvement fund 401-800 for payment of legal settlement. So I would entertain a motion to introduce a second and a third.
Move to introduce.
Second.
Third. And that was for a public hearing on the 16th. So the motion was made by Mr. Wallen, seconded by Mr. Cross. Public hearing was set by Mr. Johnson for 6/16. That will be at 11 a.m. or possibly 11:10 a.m. We'll work it out with the clerk because we have a work session that morning on bikes. So then I'm not sure that we are prepared already to have an executive session. This meeting is just scheduled for half an hour today. So the intent for the meeting on the 16th will be both to have an executive session on which we will be briefed on the settlement terms as proposed before we come to action on that item that's on the agenda for that day. And so what I've suggested to Mr. Owens, the municipal attorney who's kind of riding herd over these questions, is take the opportunity, if you are amenable, each as members or in small groups, to have a briefing with him so that you can get his perspective on what's in the best interest of the municipality, so that when we get to the meeting on the 16th, we are all more prepared for the conversation that will come. So, Madam Clerk, it's an unusual thing. I'm not sure, is there an opportunity on this agenda to have a conversation at all about this item so that maybe if anyone wants to put any questions on or not, we can get that while we have just a few minutes.
Yes, Mr. Chair, you can, you've introduced the item. I think you can probably have a general discussion. I'm not, typically on a public hearing item, you can't debate it before the public hearing. So there is that rub, but
I know we can do. So
Okay.
I think what we can do is I will just give the floor to the attorneys if they want. You don't have to right now to lay out anything you want us to hear, but then members who might have inputs or questions, we have audience or member comments on the agenda that you can use that as an opportunity to talk about these items. Ms. Halsey, yeah, come on up, microphone. And again, this is not a time to debate. The item is set for public hearing. We'll debate after that.
Through the chair, Municipal Attorney Ann Helzer, thank you so much for calling this meeting about this important issue. I'm sure you have a lot of questions. We are here in good faith to try to bring you into some of the ins and outs that particularly Mr. Owens here has been handling. So if without any further questions, I will allow Mr. Owens to kind of bring you a brief overview of some of the things we've been looking at with regard to this issue.
Through the chair. I'm Bob Owens. I'm with the Law Department. I've been managing this case since before the action was filed. And I'm not quite sure what you want to hear, but at this point, just briefly in terms of how we got here. I recall watching an assembly meeting when Lance Wilbur got up and acknowledged to the assembly that there was an appropriation needed to proceed with this project. And it was at that time that I became aware of some of the issues. And subsequently, in looking into this and trying to see our way through it, the dominoes kind of fell into place. The assembly decided not to proceed with that appropriation. It led to a demobilization from the project where Roger Hickel was given a formal notice that we were going to terminate the project for convenience, which triggered provisions of the municipality standard specifications for unwinding a project. They proceeded with that, submitted a bill in accordance with the mass procedure. We had independent outside engineering firm review that bill to determine accuracy and the like. It came back generally acknowledging the amount due. There was a $3,700 discrepancy. Some discussions followed. Ultimately, Roger Hickel Construction chose to file a lawsuit on the basis, asserting three claims, basically. One is breach of contract. One is quantum merit, which is an equitable theory. They're entitled to be paid for the benefit that was conveyed. And the third was just a breach of good faith and fair dealing. In responding to that complaint, we looked at all the facts that were asserted, and they were pretty well stated. And we ended up acknowledging the factual statements that were in the complaint. And shortly thereafter, based on those admissions, I think, Roger Hickel filed a motion for judgment on the pleadings. In other words, it basically says we're entitled to a judgment promptly without going through discovery and the usual pretrial procedures because there really aren't many facts in dispute. And that's the posture of the case right now. That motion is pending. After filing that motion, RHC delivered a letter to us that offered to settle the case for the amount claimed without interest, costs, or attorney's fees, and gave us a deadline. We asked for an extension so that we could coordinate appropriate meetings with this body. The deadline currently for response is June 19th, but they've been very cooperative. I think if there are ongoing discussions, that they would give us a few more days. So that's how we came up with June 20th for the next date before this body. That's it in a nutshell.
So an offer is made to set times with Bob and have conversations if you have specific questions. I have had that opportunity and I have some thoughts. We'll see what happens between now and then. Anyone else? Mr. Gates?
Thank you. I just wanted to ask Mr. Owens if there may be a slight correction to your summary. One is that there wasn't a sufficient appropriation for the project, but I think it was the appropriation was in place, but the contract amendment required approval, an amendment that would have added some $1 million to the contract that was already signed. But it was the assembly approval of an amendment required by code that wasn't obtained, and that was the problem. But not that the appropriated monies weren't there. So, thank you.
Thank you, Mr. Gates. Anyone else? Mr. Krause?
Yeah, just for clarification, and then, so the settlement offer that we'll be looking at does not include, it sounded like you said, the interest. So the materials that we've taken possession of and are currently secured in municipal property, they're not seeking lost opportunity costs or interest on those as per the settlement. Is that my understanding?
That's right. There has been some material delivered, as you probably know, and that was all factored into the invoice. So what remains reflects those credits. And so it's just the bare nature of the claim without any carrying charges, finance charges, interest costs, or attorney's fees is the settlement proposal.
Thank you. And another future conversation we'll have is what do we do with those materials? Whether we proceed or don't, that'd be this part of a separate conversation. Thank you.
Yeah, definitely not the topic of this one, but we'll get there. Anyone else? Hearing and seeing none. And I apologize. I should have asked the 8th floor for clarity on what they intended for today, because practically speaking, this could have been accomplished on the regular agenda tomorrow night. We didn't need to meet, but for that, if I'm not hearing or seeing anyone else, we'll move on to audience participation. Oh, Ms. Hauser.
I just wanted to strongly encourage, through the chair, that you reach out to me. And certainly Bob has expressed his willingness to answer any questions. We do have a lot of information and we're happy to share it. And we do want to hear from you. So if you do have questions, please reach out to me or to Bob, if that's all right, or to both of us. And I will make sure that you get your questions answered so that you have a full understanding of what we are looking at. Thank you.
Ms. Braga.
I don't know if this is okay for you to answer, but have you ever seen contracts like this that a worker goes ahead and does the work without the required, signatures? Have you had cases like this before and has Hickel ever tried to do a job without the purchase order or I'm sorry, I don't know the terminology.
So I'm going to jump in there and say that's a great question to ask Bob offline. And I don't think now is the time for that question. And I think the answer will shock and amaze, but it's better. Let's hold that one for off because it gets into the debating of the question that we're going to pick up on the meeting of the 16th. But that is, I think, a very important question. Anyone else? Hearing and seeing none. Now we'll move on. Oh, go ahead, Anna. Ms. Brawley.
Yeah, so I do intend to follow up so I can have a bigger conversation, but just to, and you can tell me if this is out of bounds, just to clarify. So it sounds like one of the items in dispute is whether or not that 4.9 million has been not appropriated, but that it would be legally available. Is that correct? Or is that something that's not easy to answer right now?
So there is an email that I have in a request for an opinion from the municipal attorney's office on whether or not those funds are still available or whether they have been swept, because we have an opinion that says they have been swept. And so, and there is some conversation about, there's an appropriation item on the agenda for the meeting on Tuesday that appears to use the same money that was swept for that purpose. And so if it's being used in one category, it can't be used in another. And so, because it can only spend it once. So that's an important question, and one that I have a request out. I haven't had an official response back, but if we get before us two opinions, I think it would be a decision of the body, which one is the one that we agree on. Anyone? Nope. I would just say we haven't seen the settlement. I intend that at the executive session, we should see the settlement, the actual documents like we did the last time, and have an opportunity to understand that part of it as well as the expenditure. And with that, now we'll move on to audience participation. Anyone from the audience, the public, wish to be heard? Anyone at all? Okay, I'm not seeing anyone. Next, we'll do audience assembly member comments. We'll start with Mr. Martinez,
No comment.
Mr. Rivera,
No comment.
Ms. Braga,
No comment.
Mr. Myers,
No comment.
Ms. Brawley,
No comment.
Mr. Cross,
No comment.
Mr. Johnson,
No comment.
Mr. Volland,
No comment.
and I too have no comment. And with that, we are adjourned.